Criminal justice come to order. We recessed, and for the record, still have a quorum from our last meeting, but other members are in other committees and will be here shortly. While we're waiting the arrival of additional members, let's get started. And I'll first lay out Senate Bill 2479 by Senator Zaffarini.
Thank you, Mr. Chairman.
And I understand you have a substitute, which we won't adopt till we get a quorum, but would you go ahead and explain the substitute, and that's what you can testify on.
I will. Thank you, Mr. Chairman. Senate Bill 2479 relates to procedures regarding certain persons who are or may be persons with a mental illness or intellectual disability. It is a recommendation of the Judicial Commission on Mental Health, of which Senator Huffman is a member, and they identified several issues in the criminal and civil code that the legislature should correct. Generally, the bill would improve mental health treatment options for persons charged with nonviolent misdemeanors, reduce the strain on the criminal justice system, and enhance outcomes for those with mental outcomes. The committee substitute removes provisions which permitted law enforcement to seize the firearms of a person subject to an emergency detention order, a section which provided for the deferral of arrest for nonviolent offenders receiving emergency mental health service, and clarify that while determining a defendant's mental competency, the defendant's custody status would remain unchanged.
Very good. Clerk, call the roll.
Senator Whitmire?
Present.
Senator Hinojosa?
Present.
Senator Huffman?
I'm here.
Senator Miles?
Present.
That's 4, sir.
There being 4 members present, we have a quorum, and so Senator Hinojosa sends up committee substitute for Senate Bill 2479. Is there objection to adoption? Chair is none. Senator Zaffarini just did a fine job of explaining. And now we'll call witnesses. And because of the demand on our times, I'm going to do my best to restrict folks to a 2-minute testimony. I'll use my discretion if we are in extending the time, but try to cooperate and let us get through this hearing successfully. Jane Bland would like to testify. Ms. Bland, if you'll state your name and who you represent, please.
Good morning, Chair Whitmire. I'm Jane Bland with the Texas Supreme Court.
Proceed.
Thank you very much, and thank you to all the senators, in particular to Senator Zaffarini, who's so much assistance to us all through her role on the Judicial Council and also through the Judicial Commission on Mental Health. I'm here really to talk about Senate Bill 2479. It is the culmination of work done by the Legislative Research Committee that the Texas Supreme Court and the Court of Criminal Appeals authorized upon the creation of the Judicial Commission on Mental Health. It works to improve the court's interaction with the administration of justice for youth, adults, families, and the public when someone presents with mental health needs. In this bill, sponsored by Senator Zaffarini, the priorities are to improve legal processes related to mental health law, in particular competency restoration, emergency detention, and early identification of persons with mental illness in connection with the commission of Class C offenses. So one effort is to reduce the wait list for those not competent to stand trial. The time needed to reach these services often exceeds the maximum sentences for those charged with misdemeanors. So one provision of the bill would remove them from the wait list and divert them to outpatient competency restoration so long as they were charged with a nonviolent offense and had not been charged with any violent commission of a crime in the last 2 years. In connection with emergency detention, law enforcement often have to wait while the individual they're transporting for emergency mental health services under a warrant is medically screened or treated. I'm out of time. If you have any questions, I'm happy to answer them, and I will just say thank y'all for your consideration of this bill.
Thank you, Ms. Bland.
I have a question. Sorry.
Yes, ma'am. Senator Huffman.
Yes, Senator Huffman.
Good morning, Judge.
Good morning.
You used to be my constituent, but now you're Senator Whitmire's.
I am.
I
That's
miss you,
correct.
yes.
That is absolutely correct.
But anyway.
I'm
You've got more
I'm
time.
well represented
Would
in
you like
both-
more
in-
time is what I want to know.
no, Senator. I understand how busy you are.
Yeah.
So I'm happy to answer a
Next time you
question.
sit down, say, it's nice to be in front of my own senator, and you'd say, just turn the clock off.
Well, I was trying not to
No, you're doing a fine job.
push.
I do
you know,
miss the old
don't want-
neighborhood, though. But
Yes.
well, anyway,
yes.
that wasn't what I was going to ask you.
Yes, yes,
So, my question is, and maybe it's to Senator Zaffarini, and maybe in your role as a judge, you prefer not to answer this question, so I'll ask Senator Zaffarini. So, is this an automatic that certain misdemeanors do outpatient competency restoration, or you can understand the concern with all the work we've done on bail reform and so forth. There are some misdemeanants who, for various reasons, shouldn't be automatically released to outpatient.
No. Well, we have Christy Taylor, who's the Executive Director of the Judicial Commission on Mental Health.
Okay.
So we'll-
So yeah, it's probably not for Judge Bland. Yeah.
Okay, I'm happy to answer. The bill's limited to nonviolent misdemeanors, and the judge has discretion.
And I get
So,
that.
and they have to be evaluated and found suitable for outpatient.
Okay. Well, that just concerns me because some
I-
judges, I'm not talking about you.
Well, they may have a history, they
Discretion.
may have a history of violence, and they may not,
Exactly. So
they may
I'm
have a
just
felony record, but before the judge for this misdemeanor count,
Absolutely.
I hope there's a risk assessment, and as Senator Huffman pointed out, that it's not automatic.
Absolutely, and I'll let Christy follow up, but
Okay.
I understand that concern, and we would absolutely be happy to address it if it's not adequately addressed for the committee's needs.
Okay, thank you very much, Judge.
Thank you.
Chairman,
Yes,
and I'd
ma'am.
like to thank Justice Bland for her work.
Oh,
Sure.
it's my pleasure. Thank you all so much. I hope you have a great day.
Good job. Brent Carr?
Mr. Chairman, members.
Good morning.
Judge Brent Carr recently retired and now doing some work for the Judicial Commission on Mental Health. I think Justice Bland covered pretty much everything that I would add. I could also point out that, for jurisdictions that have them, we also have in Tarrant County and most of the urban counties, we have jail-based competency restoration if for these lower level offenders that are at least Class B, if that is an appropriate circumstance as well. But other than that, that would be about all I have to add, and I'll be
Very
happy to, as a resource, to answer any additional questions.
Any questions of the witness? Thank you, Judge, for being here.
Thank you.
Christy Taylor? State your
Good
name.
morning, I'm Christy Taylor. I'm testifying on 2479.
Yes, ma'am.
Would you like just to ask any questions? I would follow up with Senator Huffman's question that the intent of this part of the bill is to reroute those misdemeanants who would never make it to the state hospital anyway, because the maximum time for the offense would be 6 months. And so they would never get through that 2-year waiting list to get to those competency restoration services. So some states are actually prohibiting any misdemeanants from going onto that list, but we thought in Texas this would work better.
Senator Huffman?
Yeah, just briefly, and I see Senator Colcore sitting there on the front row. I will say that this session, we're making significant, if not massive, improvements in our forensic beds and so forth and how fast people get it. I mean, we're spending almost $3 billion. So some of these issues, I think, are going to resolve themselves. I mean, Senator Colcourse has done a phenomenal job of digging into this very deeply. I mean, you really have. I'm not just saying that because you're sitting here. To really address this issue and speed up this process. As she dug into it, she realized that the biggest use we need of these in-state beds, inpatient beds, are for forensic needs. That's the wait list. It wasn't for civil. I mean, there was a little civil wait list, but it was almost all forensic. And she's really addressed that. I think the House is, we're going to be close. I really think something will come out of the legislature that is significant. So, again, I'm a little cautious on some of this just because even though it's discretionary, we have seen repeatedly, and I hate to keep harping on this, but judges not use their discretion appropriately when releasing individuals or making decisions about people that are put back out on the street. And even though they are misdemeanors, as Senator Whitmire pointed out, sometimes they do have a significant criminal history or violent history. And now that we're opening up that pipeline, I'm a little worried about how some of this is going to work. I will work with you, of course, Senator Zafferini. Yes. Okay, just want to make that point.
Thank you, Ms. Taylor, unless you have additional information. We have several witnesses signed up, do not wish to testify. Jackie Benestante, Autism Society of Texas is in support. Brian Mitchell, Dallas County Criminal District Attorney's Office is in support. Ray Hunt, HPOU, signed up in opposition and does not wish to testify. A.J. Loudermilk, Texas Sheriff's Regional Alliance is in opposition, does not wish to testify. Anyone else present that would like to testify for or against committee substitute for Senate Bill 2479? If not, public testimony is closed. I'll leave pending at this time.
Okay, thank you, Mr. Chairman and members.
Show Senator Benton present. At this time, members, I would bring up Senate Bill 435, Senator Middleton. I believe you have a substitute. Let me get the substitute adopted. Senator Hinojosa moves that the committee adopt committee substitute for Senate Bill 435 by Senator Middleton. Is there objection? Chair hears none. Senator Middleton, you can explain the substitute.
Thank you, Mr. Chairman, members of the committee. I want to start out today by apologizing for the delay in scheduling the hearing of this bill. And I want to thank the families here today and the families of victims here today for coming to your Capitol to speak from your heart. We all want justice for the killer in Santa Fe and all murders. And we want to allow this bill to give some small level of closure to families that have lost so much. And this is an important bill to get right, and that's part of the reason for that delay. We want to make sure that the mass murder of May 18th, 2018 is prosecuted to the fullest extent of the law, and the prosecution is not compromised in any way by this legislation. I have 4 kids, and I hope, like every parent here today, that I never know the loss of the 8 sons and daughters that Santa Fe moms and dads know, nor the loving families of Ann Perkins or Cynthia Tisdale. And I've been working with the Santa Fe families for years, and this bill is a culmination of those many meetings and visits in many of their homes of people here today. And currently, the Public Information Act accepts evidence of a crime from definition of public information, meaning that it does not have to be released to the public. A local government officer may voluntarily waive this exception, provided that they release the information to the general public. This provision in the law discourages prosecutors from releasing evidence or video of a crime that resulted in the death of a person to the victim's next of kin or victim. This bill allows, and this committee substitute allows, the Galveston County DA, who supports the bill, he's here today, to let families see the video and medical examiners report evidence from Santa Fe without subjecting it to public release. And the video evidence was explicitly put back in the committee substitute that's laid out right now. The bill also has provisions to protect against the public release or recording of the records that the DA allows the family and victims' families to view, and that they may be required to sign a confidentiality agreement. And this bill is a simple next of kin rights legislation that helps ease some of the pain of not knowing what happened and will help with some small level of closure after a tragedy like Santa Fe, where we had so many victims that lost their lives. Everyone processes grief differently, and I sincerely hope that this bill will help the families in grieving their traumatic loss from Santa Fe. And with that, I yield for questions.
Any questions? You have done a really fine job of handling a difficult, delicate piece of legislation. It was scheduled 2 weeks ago. You do not have to apologize for the rescheduling. It was a decision of the chair and the committee to do it right, and there we'll see as we go forward. It's still a delicate issue. We're very respectful of the family's wishes, and 2 weeks ago it was best to get it in the form that will pass through the legislature. So thank you for your hard work and sensitivity to the issue, and it's a shame that there are people in our communities that would politicize this issue and actually attack me for some unknown reason of chairing my committee in the proper way of making sure all the stakeholders and the families are respected, and you have an opportunity to get the bill in the form that you wanted. So we'll see today we have families in support of your legislation. I actually have cards from families in opposition, so it is still a very delicate matter to deal with, a tragedy that we wish we weren't here discussing. So thank you. You've done a fine job, and so let's...
Thank you for your help, Chairman, in moving this bill forward.
Let's let the process work. It is what the legislature is about. It's a bipartisan effort of communities from across Texas that have had input. So we're going to do it right, and that's why we're here this morning. So thank you. You've done a great job.
Thank you.
Jack Rody, Galveston County Criminal District Attorney. So Senator Flores present. State your name and who you represent, please.
My name is Jack Rody. I'm the Criminal District Attorney for Galveston County. I'm here to testify in favor of the bill. Mr. Chairman, members of the committee, thank you for hearing me this morning. As Senator Middleton has rightly pointed out, and I know as everyone on this committee recognizes, the family members of people killed by violent crime suffer unspeakable tragedy that we'll never really understand. That's compounded when they don't have access to information about the crime that took their family members from them. And it's heartbreaking for them. It's frustrating for them. It's equally frustrating and heartbreaking for those who hold the information but aren't able to share that with them. And that is why we're here. The problem is that the public information laws of Texas don't currently grant a special right of access to immediate family members of violent crime victims. And that runs in direct conflict with the prosecutor's responsibility to not release information prior to trial that would compromise the trial. And so, to date, it has prevented us from being able to share that information. This bill would, in this situation, allow us to at least share some of the information with the family members that we've been unable to before. It's been years of waiting for them. I think this bill gets us a long way of where we need to be, and hopefully it will allow them to get some information and answer some questions they've had for a long time. So we support the bill, and thank you for your work on it.
Mr. Rody, is it your testimony that this legislation, if passed, will not compromise the investigation in any way?
If the way the bill's written, it restricts anyone who views the information from releasing that information publicly. And so if that holds true, then it would not compromise our prosecution.
Do you believe it will help with your closeness to the family and the victims' families? Will this help the healing process, in your opinion?
I think many of the families, Mr. Chairman, have suffered from uncertainty for a very long time, and that has presented barriers to them going through the grieving process.
Any questions?
I have a
Senator Huffman?
Yeah, thank you for being here, Jacqueline, for your work on this. And I'm completely supportive of the legislation. I'm just curious about something. So I'm thinking back on prosecuting. So it's your belief that, like, as you prepare for a trial, you can't show the families the autopsy photos? Because
Correct.
in the old days, you know, we would bring the family in, and if they were going to testify, especially if they were going to identify, you know, the body or something along those lines, that I would prepare the family by, but if maybe the law's changed or there's procedures.
If it's not related directly to their testimony, in this situation, it's seeing the full autopsy reports and also wanting to see video from this, in our case, a school, that kind of thing.
So it's a little more than just an ID in court or something.
Yes, ma'am.
So it's really a protection to make sure that legally the DAs are not compromising the case.
That we're not compromising the case or violating the ethical rules about releasing information into the public prior to trial.
Okay, and a family would be considered the public under the way the law is interpreted these days? I mean, it was different 30 years ago.
That's correct.
than it just was.
If the information is shared with the family, then it's considered a public release, and
Okay.
then anybody who has
Okay.
an interest gets to
So this
access.
kind of legislation then is necessary to facilitate the families having these opportunities?
That's correct, Senator.
Okay,
Mr.
thank you.
Chairman,
Senator Hinojosa.
thank you, Mr. Chairman. But I guess this situation applies when the defendant was deceased or killed in the process, and is not, you will not have an actual trial in this case.
Well, in this case, we do have a trial.
Okay.
We have a live defendant. Because of his current incompetency to stand trial, we have not been able to have trial coming up on 5 years. The bill allows for prosecutors to retain discretion about what information to share, which I think is critically important. But in this case, we do actually have a criminal case pending.
Okay, thank you for the clarification.
Thank you, and thank you for the job you do.
Chairman, thank you,
Texas.
members. Thank you all.
Rhonda Hart. Ms. Hart, if you'll state your name and who you represent, please.
My name is Rhonda Hart, and I'm the mother of Kimberly Vaughn that was shot and killed at Santa Fe High School. 5 years ago exactly, I took my children to Florida. We posed in front of the castle at Disney for that photo that you have with you right now. We went to the wizarding world of Harry Potter and drank butterbeer. It was the last time we ever took a trip as a family of 3. Exactly 30 days after that photo was taken, a gunman entered Kimberly's classroom, killing her and 9 other people. Every spring, I get reminded of this trip via my Facebook memories. Now springtime means that Jack Rohde sends me an update on the mental health status of Kimberly's shooter. He is not currently fit to stand trial, and we've not had any information released about Kimberly and how she died. It's not fair, and it's inhumane to keep prolonging this trauma for me and the other families. During this legislative session alone, we have traveled to Austin over 6 times to fight for SB 435 and HB 3729. I've met with almost all of your offices and on the Homeland Security Committee, retelling my story each time, re-traumatizing myself. I know how long it took for Kimberly to cry when she was born, but I don't have any information on how she died. I work diligently to get past the PTSD from the shooting. I attend therapy every month. I take daily medication. Hearing about the shooter's lack of mental stability sends me into a panic attack, and I regress. I have to call my therapist. I have to leave the location where I'm at. I have to take my medication early. I have to surround myself with grounding ideas and limit what kind of news I watch for the day. I have to sit down with my dog at my side and put my hand on him to regulate my breathing and bring my heart rate down. I have to fight to keep myself in the present because I have to parent my surviving child. He needs me too. My ask is that the committee supports SB 435. I know most of y'all are parents. Some of you are grandparents. Not knowing how Kimberly died keeps me awake at night. SB 435 is my only hope to gain information about the shooting and finally grant me some peace. Thank you.
Any questions? Thank you, Ms. Hart. Obviously, words can't describe adequately our sympathy and regret, but we're trying our best to give you some relief today, and thank you for traveling to Austin.
Thank you.
John Conan.
Good morning. Hello, my name is John Connard. I am here today in support of SB 435. I am Jared Black's uncle, Santa Fe High School shooting victim. I am here today to speak on behalf of Jared's mother, Pamela Stanich. This bill is extremely important not only to our family, but many other families affected by violent crime in the state of Texas. From the very moment of learning about Jared's death, we have had countless questions to which we have received few answers. What, when, why, and how are common questions asked about the death of a loved one. Taking into consideration of how painful these answers may be does not negate the need to know. An aching heart and grieving mind require these basic answers to process the tragedy of which it is undertaking. I would now ask that every member of this committee and legislative body place themselves in the position of which our family now finds themselves. Just days ago, you experienced the most horrific and tragic day of your life. You made phone calls to tell your mother that your son or daughter has been murdered. You are emotionally shattered and numb with sorrow. You stand across from the district attorney, who also has tears in his eyes. You ask the questions that have been eating at your soul. I am sorry, but I cannot tell you that. You hear his words, but can't make a reasonable comprehension of them. You say, I have a right to know what happened. And he replies, I am sorry, but you will have to wait until the trial. You realize that if or when your questions are answered, that you will be in a packed courtroom hearing the information being told to a jury and not privately to you. If you cry out or respond, that you could possibly be removed from the proceedings, as it may violate the defendant's rights. Passage of this bill will allow the smallest consolation of comfort to grieving families. While this legislative body cannot undo the tragedy and reasons for our sorrow, you can help reduce the trauma that plagues our hearts and souls. Passage of this bill into law will allow the district attorney, in a confidential setting, to disclose relevant and gut-wrenching facts about the final moments of our loved ones' lives and how they were ended. I humbly ask this committee for swift and unanimous passage of this bill to the floor for a vote of the whole legislative body. You have an opportunity to help every Texan that has an unfortunate status of being a victim of violent crime learn the worst news of their lives in a private setting instead of a courtroom in which their natural emotional response could place in jeopardy the very justice that they seek.
Thank you. Thank you for being here. Rosie Stone?
My son's name is Chris Stone.
I'm sorry, Ms. Stone. State your name first.
Oh, my name is Rosie Stone. I'm from the Santa Fe school mass shooting. Since I've lost my son, there's one thing that I've learned, is that the moment that anybody dies in a school setting, they lose all their rights. As a parent, I lose all my rights, and that is not right. Nobody came into that school and asked my son, can I take your life? Nobody asked for that permission. He was robbed of his rights, and that is not right. In 5 years, I have advocated over and over and over again that us parents should not be left in the dark. Just because somebody made the decision to come in and take my son's life should not give him the right to still have a thumb on my life. Because he sits in a hospital, I can't know nothing. I cannot know anything about my son. I can't know how he died. I can't know about all the failures. How can we fix something when we don't know what was broke? How can we fix something when nobody will give us confirmation about anything? It's heartbreaking. You have to live with the fact that you lost your child, and then you have to live with the fact that, I'm sorry, I can't tell you anything about it. That is no way to live. It's torture. And I don't know if you'll understand it, but it's pure torture. How does anybody expect us? Move on, Rosie. Do the best that you can with your life. How am I supposed to do that? Living with the unknown is just as worse as trying to make the decision. Should I bury my son or should I cremate him? I hope that I don't want nobody to ever walk in my shoes. But you know what the cold reality is? They will. The next killer is out there right now. He's planning his next murders. And there will be somebody else in my shoes. We can give them a little glimpse of hope that they can get the information that they need so they can live. Because it's hard living this way. And that's all I have to say.
Thank you, Ms. Stone, for working with the committee and your senator, and your coming to Austin will make a difference. We're doing our very best, and obviously we're sorry about your tragedy. So we're going to pass this piece of legislation for your son.
Thank you.
You're welcome. Allison Steele. Ms. Steele, state your name and who you represent.
Thank you, Mr. Chairman. My name is Allison Steele. I'm representing myself, and I'm the mother of 19-year-old murder victim Kaylee Mandotti. 1 week ago today, I came to this Capitol and gave my full-throated supportive testimony to the identical House bill, to the bill identical to 435 in the House. But I have, as you know, there have been at least two rounds of recent changes to this bill, one of which only dropped last night. And I want to start by saying that there's not a single person in this equation who wants to take anything away from Santa Fe. They have stepped up and met their legislative obligations. They've been incredibly brave, and I have infinite respect for them. But there's another side to this issue that needs to be stated. There's a much larger issue here, and someone needs to state it, so a few of us will. Murder survivors are murder survivors. We're a single class of affected party. I'm a crime victims advocate and a murder survivors advocate in particular, and it does not matter to me whether a survivor is from Santa Fe, Texas, or El Paso, Texas, and I would argue that it shouldn't matter to anyone else either. We are all constitutionally guaranteed a right to equal protection under our laws. And let me tell you what, this right here is one of the most protective laws for crime victims that I've ever seen. Nothing Texas can strip away those very fundamental rights that are given to us under the 14th Amendment. And I'm not a constitutional expert, so what I had asked this committee and every stakeholder in this equation to do, who drafted this sub late last night, was please explain to us how it does pass constitutional inspection. On its face, you've written a bill that has very good intentions. It benefits a handful of families, however, while leaving thousands of other people in equivalent circumstances out in the cold. And to me, that doesn't pass moral inspection at the very least. So thank you for hearing me.
Thank you for traveling to Austin, your testimony.
Do we have a copy of this?
To be honest with you, I don't know. Wait a minute, I wouldn't go publicly.
Okay.
Just a second, let me check. Ms. Steele? Senator Huffman has a question.
Just briefly, because you just mentioned about something new that you thought was unconstitutional, can you point to what part of the bill, just so I can glance at it? The part of the bill that I specifically object to is H3, which is the definition of a qualifying crime. That's the one that's been scoped to exclude anyone who doesn't fit that definition, which is pretty much everyone, to my knowledge, except for that one group. Okay, thank you. That was my question.
Why don't I get some copies? Some copies. Jessica Gehring. If you'll state your name and who you represent, please.
My name is Jessica Gehring, and I'm representing myself.
Very kind. Proceed.
As just like Allison, I was here in favor of the same bill in the House. but as the bill as written, it excludes a lot of us. My fiance, Austin Utley, was brutally stabbed in 2019. He was one of 9,000 Texans murdered since Santa Fe. Some murders get attention and others are forgotten. I am asking the committee to make sure that you remember every single murder victim. Santa Fe deserves answers. Every murder victim's family deserves answers. Austin's murderer has never spoken. The only answers that we got were in his autopsy. It took 128 days for us to get the autopsy, and we were tortured every night, wondering if he suffered. The family of Brandon Truman, who was murdered on October 2020, they want to know if he was still alive after he was shot and set on fire. The family of Arlene Alvarez has been waiting over a year to have access to evidence. The family of Catherine Mowry waited 37 years to have access to their loved one's autopsy. Homicide survivors already have a high risk of post-traumatic stress disorder, major depressive disorder, addiction, and suicide. We become social pariahs. Our lives are over as we knew them. Denying families access to the only answers they may ever get is cruel punishment of the innocent who are already traumatized.
Any questions? Thank you for your witness testimony. Letitia Ybarra. Ms. Ybarra, if you'll state your name and who you represent.
Good morning. Letitia Ibarra. I represent myself. I am the mother of a 24-year-old. My daughter was murdered in 20.
Speak in the mic a little.
Oh, yes. Letitia Ibarra, and I represent myself.
Yes, ma'am.
My daughter Jessica was murdered in August of 2020 in your area. I'm one of your constituents, Senator Huffman. Last week, it was my plan to attend these meetings in support of this. As a mother of a murdered child, I would like answers too. Regrettably, I now oppose it. And the only part that I oppose is the exclusion of me and my family from this. What you have to understand is I have not yet had the stomach to look at or know really the details of her murder, but that will happen when we go to court. The absolute worst day of my life was not the day that I found out that she died, but the day that I found out she was brutally murdered. That was, the sound that came out of my body was gut-wrenching and almost animalistic, and I scared the hell out of all my family. I can't imagine being in that vulnerable state in court in front of the person who intentionally did this to her. So what I ask is the respect and dignity to see that in private, process it so that I am ready for court, so that I'm not asked to leave court. I can sit and witness justice for the murder of my daughter. And again, not do it in front of the man who did this to her.
Senator Huffman.
Thank you very much for being here. How long ago was your daughter murdered?
2.5 years. Was
I missed that in the beginning.
August in 2020.
Right. And so is it still set for trial, or?
It's not gone to trial yet. We're pending, I think this week or next week, we're going to reveal the results of sanity evaluations.
Okay.
And then we'll go from there, but we're potentially going to trial.
Okay.
We're just
Which
waiting
county
on that.
do you live in?
Harris County. Yeah,
Harris County.
I'm your constituent.
Yeah.
Yeah, so we're in Harris County. So that's where we're waiting on, and that will be actually soon. I understand the results have come back.
Yeah.
And we have a court date next week to see where we go from there.
It is a long and torturous process.
Absolutely, it is. You know, I don't, there's, Bond said, I don't know day to day whether he's going to get out and come after me. I don't know exactly what happened to her. I know that she was brutally beaten first and then stabbed in the neck multiple times.
Well, God bless you.
That's all I know. But again, I'll have to see photos of that in person.
Yes.
In front of him.
Yes.
Thank you, and thanks for having the courage to come down. No piece of legislation is perfect.
Right.
It's a process. We will take your concerns forward, and might be another piece of legislation, or we'll see how we can address your concerns and others' concerns as Steele's as this piece of legislation goes forward. I know it was a delicate drafting to try to not interfere with the prosecution, which we all
Right, which none of us want.
Yes.
You know, I don't want to do anything to
interfere with
that whatsoever.
Well,
Again,
that's-
I would like to be mentally prepared to be
Sure.
a good, not witness, but
Yes,
to
ma'am.
be ready for court as her mom.
Well, and we want to help you all we can. I just know, and it was part of the decision to not have the hearing 2 weeks ago, to continue to try to perfect this very sensitive piece of legislation. And as we go forward, your input and other victims' families will certainly be consulted, and we'll try to do the very best we can without compromising any prosecution.
Right.
So,
Thank you.
Thank you.
Thank you so much.
Be safe. Anyone else present would like to testify for or against committee substitutes for Senate Bill 435? If not, public testimony is closed. Senator Huffman, are y'all ready to vote this morning? Senator Huffman moves that committee substitute for Senate Bill 435 be reported back to the full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire.
Yes.
Flores.
Aye.
Hinojosa.
Aye.
Huffman.
Aye.
Miles.
Aye.
King.
Aye.
6-0.
There being 6 ayes, no nays, committee substitute for Senate Bill 435 is reported back to the full Senate with a favorable recommendation. I would prefer this go to the Senate floor, but concerned about the closing days of the session. Senator Huffman, you want to move that be certified for local?
I do, but could I just say something real briefly?
Certainly.
I've actually been texting with the sponsor, and I do, sometimes you listen to testimony and it changes the way you think about something.
Makes a
I do
difference.
think we should think about opening this up to, it's just not fair so I'm going to work with Senator Milton and DA Hody, if you will agree to work with me and help me with this, to try to, I don't know if we can do it, but we will try, and if so, then, but I'll work closely with Senator Middleton to
Very-
see. We
very
don't want to
good.
mess up the bill, so the way it is, we won't change it, but if we can change it to be more inclusive, I think it's the right thing to do, in my personal opinion. I mean, I don't know if we'll have support, but I think I can probably.
Thank you, sir. I can't think of a better person to do it than.
So, you could put it on local, but it would be nice to be able to take it to the floor so that we could try to add something to it.
The only reason I would certify it for local, and that'll be the decision of the sponsors, Senator Milton,
Yeah.
and the scheduling of the leadership. I wouldn't want it, and this is a priority, obviously, but it's another opportunity for the bill to be heard on the Senate floor. So you want to move that be certified for local and
Yes.
consent, with the understanding that a lot of work can be done even before it's taken to the local or the general calendar. So is there objection to certifying for local? Senator Huffman moves that Senate Bill, committee substitute for Senate Bill 435 be certified for local and consent. Is there objection? Chair has done so granted. But we will definitely be in consultation with the sponsor to try to address the concerns of other witnesses. Thank you, members. Next, Senator Springer.
Work on it if we can. If not, we won't mess up the bill.
How about, Senator Springer, yours is going to take a little longer than West. Let me address Senator West. Senate Bill
Just needs to.
840, Senator West.
Thank you, Mr. Chairman. Members, on Saturday, October 22nd, 2022, in my senatorial district, something unimaginable and unthinkable took place inside the walls of the Dallas Methodist Medical Center, a place dedicated to saving lives. An already engaged gunman, a person on parole, inexplicably opened fire on 2 hospital workers from a hospital room, killing them both after hitting the mother of his recently born child repeatedly with the same handgun. He was shot and subdued by hospital police, ending the fatal attack on 2 innocent medical professionals. The Jacqueline Polka and Katie Annette Flowers Act is one of a package of bills filed by members of the Dallas legislative delegations and others who have determined to eliminate, if possible, the chances that a similar event will happen again. Senator Huffman already passed from this committee a bill, and Senator Hinojosa has a bill also. I think all three of these particular bills will in fact handle or mitigate the chance of this occurrence again. If passed into law, Senate Bill 840 would increase the penalty of assaulting certain hospital personnel from a Class A misdemeanor to a third-degree felony offense. It addresses offenses that take place while a worker or workers are on duty at the medical facility where they are employed. The attacker, in this instance, was on parole, released following conviction for 2 aggravated robberies. Senate Bill 840 would amend the Penal Code, Section 22.01, by adding subsection 9 to imply intent, using language saying that an actor knows the person they are assaulting is a hospital personnel. It also amends by adding Section 1A that defines hospital personnel. The Texas Medical Nurses Association is on record saying that workplace violence, particularly against nurses, started increasing even before the pandemic, and has asked for us to, as legislators, to help protect healthcare workers. Now, we've received some questions from the Texas DRXT that represents disability rights concerning this particular bill, and we pledge to work with them to make certain that we make certain there's no unintended consequences as it relates to persons with mental illness or disability. I think there aren't any, because you have to have the culpable mental state in order to be charged with this crime.
Any questions of the author? We do have witnesses. Steve Rowland. State your name, who you represent, and let's try to observe the 2-minute allowance.
Yes, thank you, Mr. Chair. Members, I'm Steve Wollab with the Texas Hospital Association. I'm here on behalf of our over 470 hospital and hospital system members, testifying in support of Senate Bill 840. Preventing violence against our hospital staff is a priority for Texas hospitals. We sincerely appreciate Senator West for filing Senate Bill 840. We were all shocked and saddened by what happened at Methodist Hospital in October. The tragic events leading to the filing of this bill are a stark reminder of the potential risks that healthcare workers face when they show up for work. Senate Bill 840 is a violence prevention measure. In late 2022, THA surveyed its member hospitals on a variety of workforce issues, including workplace violence, to better understand the workforce challenges impacting our member hospitals. Responses to the survey indicated that violence in hospitals has significantly increased or stayed the same since the start of the pandemic. 61% of the responding hospitals reported violent severity has also increased. We're asking you this session to significantly fund an increase in capacity of our state's nursing schools. We also strongly support efforts to ensure a safe work environment for hospital staff. THA is supporting several legislative initiatives this session directly aimed at reducing workplace violence in healthcare. THA supports the bill's broad application to include any person, even other hospital personnel, who assault hospital staff. However, we want to be clear that THA does not support the criminalization of mental health and believes that this bill will not lead to any increase in charges being filed for the very reason that was just mentioned in the bill layout. I want to thank Senator West for authoring this bill and for working with us to keep hospital personnel safe. Thank you for the opportunity to testify today, and we would appreciate your support of this bill.
Thank you, sir, for appearing. Jennifer Concho. State your name, please, who you represent.
Yes, good morning. My name is Jennifer Catchell, and I am here on behalf of Dallas County District Attorney John Creuzot, testifying in support of Senate Bill 840. There are only certain instances in which an assault is a felony offense when committed against specifically designated hospital staff. Senate Bill 840 would add a provision to the Penal Code to protect all hospital personnel who are assaulted while doing their job. Currently, only when emergency services personnel are specifically providing emergency medical services when assaulted does the law deem this a felony. This means that if a hospital staff member is assaulted while providing discharge instructions to a patient, a postpartum nurse is assaulted while caring for a new mother and baby, a janitorial staff member is assaulted while keeping the hospital clean and safe, or a hospital social worker is assaulted while providing services and resources to a patient and their family, these offenses would not be a felony offense under current law. There is also a distinction between those who work for a public hospital, such as Parkland Hospital or JPS in the DFW area, and private hospitals. If any public hospital employee is assaulted, it is a felony under assault public servant in the penal code. While if someone performing the same role at a private hospital is assaulted, it is merely a misdemeanor. Our healthcare professionals have had a very challenging and difficult last few years, serving our communities on the front line during the COVID pandemic. Every person who works in a hospital is providing a service to our community and keeping a crucial institution running. Many of our healthcare workers feel abandoned and unprotected by our current laws. When the hostile and abusive behavior they often experience turns physical, they look to law enforcement for help. As law enforcement, we are often limited by the laws as they are currently written. Senate Bill 840 would close these loopholes so the law is clear and protects those who care for us in our time of medical need. Thank you.
Thank you. Thank you, ma'am.
Thank you.
Dan Blizzard.
Mr. Chairman, my name is Dan Blizzard. I'm here representing Methodist Health System in Dallas in support of Senate Bill 840. On behalf of the nearly 10,000 employees and physicians practicing at Methodist Health System hospitals in North Texas, we want to express our sincere appreciation to Chairman Whitmire and to the members of the Senate Criminal Justice Committee for agreeing to consider this legislation. Like the overwhelming majority of healthcare facilities across Texas, Methodist Health System facilities are not impenetrable fortresses designed to prevent anyone intending to do harm from entering, but instead are places providing an environment where those who have been harmed or are in need of care feel comfortable seeking the care they need. On October 22, 2022, that caring environment was taken advantage of when a convicted felon on parole, wearing an ankle monitor and armed with a concealed handgun, was granted permission by his parole officer to be present at Methodist Dallas Medical Center for the birth of his child. On that day, after an argument with his girlfriend, the alleged suspect opened fire and killed two of my colleagues, 45-year-old social worker Jacqueline Jackie Pokua and 63-year-old registered nurse Katie Annette Flowers, who had responded to the disturbance in the labor and delivery department of the hospital. A Methodist police officer, Sergeant Robert Rangel, engaged and disarmed the alleged suspect, thereby preventing his escape and causing further harm to patients, employees, and physicians in the hospital. To try and avoid a similar tragedy in the future, we strongly urge you to advance this legislation. Due to the ongoing criminal investigation related to this senseless tragedy, I'm not able to comment further on the events of that fateful day, nor any security measures in place at the time or steps that we have taken since then or are being considered at Methodist System facilities. Thank you, Mr. Chairman.
Thank you for coming to Austin. Stephen Love. State your name, Mr. Love, and who you represent.
I'm Stephen Love, President and CEO, Dallas-Fort Worth Hospital Council. Thank you, Mr. Chairman. Thank you, members of the committee. Thank you, Senator West, for this bill. We are certainly in support of this Senate bill. You know, when you think in terms of a hospital, emotions do run high. Some days are happy days, labor and delivery, babies are born, new life, family and friends celebrate. Other days, it's the worst day of your life. Someone is in a tragic automobile accident and they die in a trauma unit. So emotions run high in an environment that's really there for welcoming, for healing, and helping people through difficult times. And we support this bill because we want to protect patients, we want to protect families, but we also want to protect our healthcare workers so that they're not subjected to the kinds of things that happened at Methodist. The American Hospital Association also did a survey 2 years ago. 68% of nurses are verbally abused, and 44% were physically abused during that time frame. So we support this bill. We thank you for the consideration, and we thank you for your public service.
Any questions? If not, thank you, sir. Members, there's a stack of cards that witnesses do not wish to testify. They signed up in support, and with the consent of the committee, we'll read this into the record before we adjourn. Anyone else would like to testify for or against Senate Bill 840? If not, public testimony is closed. Senator Huffman moves that Senate Bill.
Mr. Chairman.
Senator West.
And I know you're getting ready to move the bill. And we're getting to a point in our society where we have to harden all of our institutions now. Our schools, our hospitals, institutions designed to help citizens. It's unfortunate that we need to do this, but those are the times that we live in. And so I ask for your favorable support of this bill.
Thank you, Senator West. Senator Huffman moves that Senate Bill 840 be reported back to full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire.
Yes.
Flores.
Aye.
Hinojosa.
Aye.
Huffman.
Aye.
Miles. 5-0.
And 5 ayes, no noes. Senate Bill 840 is reported back to full Senate with a favorable recommendation. Senator Flores moves that Senate Bill 840 be certified for local and consent. Is there objection? Chair is none. So granted. Senator Kolkars. Stringer, let's get to you then. Chair lays out Senate Bill 2593 and recognizes Senator. Oh, I'm sorry. You were coming up to the podium. I thought you.
No, sir.
I thought you were leaving when you got up and went over there. Stringer, Senator Kolkars, I believe, has a bill that won't require as much time as she was here. Senator Kolkars on Senate Bill 726.
Thank you, Mr. Chairman. This is a bill that came to our attention from a situation in my home county. Mr. Chairman and members, Senate Bill 726 provides an additional sentencing option for prosecutors by creating a new first-degree felony offense for intoxication manslaughter for defendants who caused the death of more than one individual. It was a situation that happened in Washington County in 2020 involving 4 victims, including a 6-year-old and 2 18-year-olds at the time of the collision. The defendant was intoxicated and was driving in excess of 90 miles an hour. The defendant pled to 20 years, which is the maximum the maximum sentence, even though he killed 4 people. And so I know that Sue Krigler wanted to be here today. She is the grandmother of those children, but she had angioplasty yesterday. She wanted to come in a wheelchair, but I'm not sure that her doctor would allow her. But we have met with the family. We have met with the district attorney, and I know that there's support here today from the district attorney and county attorney's office. And so I just wanted to lay this bill out.
Thank you. Eric Carcerano. State your name and who you represent. Bill's in good shape.
Good morning, Mr. Chairman. My name is Eric Carcerano. I'm Assistant District Attorney in Chambers County. I'm testifying on behalf of the Chambers County District Attorney's Office and myself in support of 726, and I'll be happy to answer any questions.
You did a very fine job. Any questions of Mr. Carcerano? If not, thank you for traveling to Austin.
Thank you, Senator.
Anyone else in support of Senate Bill 726? I do have a witness card in opposition. Rhonda Zettel. Ms. Zettel, state your name and who you represent, please.
Good morning. My name's Rhonda Zettel. I represent Jasmine Maxwell. She was my granddaughter. She was one of the 4 victims of the crash that Ignacio killed our 4 babies. and we're just trying to get it to where, you know, if.
Instead of speaking to the mic, I know
Sir?
Speak in the mic a little bit more.
We're just trying to get it to where he only got 20 years for killing 4 people. And we just want to, you know, try to help the next victims' families, you know, try to get a little bit more justice for their family.
So you signed up in opposition. You're speaking in support of the legislation?
I'm speaking against the legislation. This guy got 20 years for killing my 4 kids.
The proposed law is going to
Excuse me?
This will increase the possibility for a longer sentence for
Correct.
future.
That's what I'm wanting is a longer sentence for this crime because that's just, it doesn't make any sense, 20 years for killing 4 people.
Yeah. Okay, so actually, I think you're going to support this legislation.
Oh, I'm sorry, yes. I
no
understand
problem.
what you're
this
saying.
is-
Yes,
this
sir. I'm
is
sorry,
stressful.
I'm confused.
We're all a little stressed this morning,
Yes, sir.
okay?
Thank you.
But go ahead and proceed. We understand your feelings, and the Senator Colkhurst is addressing this legislation.
Well, I really don't have a whole lot else to say. I just want to, you know, say that, you know, what he has done for our whole community
Yes, ma'am.
has, you know, just devastated
Horrible.
every one of us. And we just hope that, you know, we hope that there's more time for stuff like this because it's just not enough.
Thank you for being here, and you're making a huge difference on this legislation.
Thank you so very much.
Thank you, ma'am. There's a large number of individuals like to testify in support or do not wish to testify. They'll be read into the record. There's actually 2 in opposition, and do not wish to testify. They'll be read into the record. Anyone else present like to testify for or against Senate Bill 726? Senator Miles, I'm sorry.
Not 726.
Sir?
I don't have 726. I do have a bill, just 2 witnesses.
I'm sorry, I can't hear you.
I don't have 726, but I have a bill that just has 2 witnesses.
Yeah, well, let me finish. We're in the process of taking a vote. Senator Huffman moves that Senate Bill 726 be reported back to the full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire,
Yes.
Flores, Hinojosa,
Aye.
Huffman,
Aye.
Miles,
Aye.
5-0.
5 ayes, no zero. Senate Bill 726 reported back to full Senate with a favorable recommendation. Senator Huffman moves it be certified for local and consent. There's objection. So Senate Bill 726 will be certified for local and consent. Okay. Thank you, Lois. Senator Miles, let me get to your bill, 2134. Recognize Senator Stringer.
B and C. Do I need to go over there?
Yeah, Miles has 2 quick witnesses, one from out of town that I'm trying to accommodate. Chair lays out Senate Bill 2134 and Senator Miles.
Thank you, Mr. Chairman, committee members. Thank you for allowing me to lay out this opportunity. On Senate Bill 2134, Mr. Chairman, I have a substitute.
Senator Miles Chair lays out committee substitute for Senate Bill 2134. Is there objection to adoption? Chair is none. Senator Miles to explain the difference.
Thank you, Mr. Chairman. In recent years, the use of telemedicine has increased access to care across the country. TJJD has used this opportunity to increase the access of care by implementing telemedicine in all of the facilities. Currently, telemedicine is mainly used in TJJD facilities for psychiatric care. Facilities use local providers to administer the care of physical ailment. These providers are only on site at TJJD facilities once per week. Although there are healthcare providers available weekly, these facilities are remote, which makes it difficult to have special healthcare providers available. What that means is if there's a health concern, these children that are in our custody and care have to sometimes wait up to a week or longer for a non-emergency care. SB 2334 closes the gap in requirement, and if the doctor is not on the facility present, the facility must have access to one via telehealth. Prohibits the use of telemedicine in the intake. The substitute allows TJJD to continue intake exams via telehealth, and the only requirement TJJD is to use telehealth when healthcare providers are not in physical one site. We have a witness, Dr. Emu and Rachel Hampton from Lone Star Justice. We're going to answer some of these questions as it relates to this bill. Mr. Chairman, and members, I appreciate you allowing me to.
Very good.
I think it'd be very informative and helpful to the citizens of the state of Texas.
Certainly. Emo Akasiku, doctor, state your name and who you represent, and let's try to keep the 2-minute rule going.
Harvard doctor.
Thank you, Mr. Chairman, and thank you to the Senate Committee, and special thank you to Senator Miles. I'm representing myself in my professional capacity. I'm currently an associate professor at Harvard University Brigham and Women's Hospital and practice in emergency medicine, critical care, and in telehealth. My former capacity was as a professor at University of Texas Houston Science Center, where I worked with the Federal Bureau of Prisons and expanding telehealth, as that's one of my areas of expertise. And I support this bill largely as a process of educating the community and hopefully the community in the state as telehealth, as we've all seen through the COVID years, as a frontline worker myself, this is an opportunity to expand access. I want to hopefully represent.
Excuse me for interrupting, but so we can get right to the issue. Have you ever been to one of our facilities?
I have not been to one of the juvenile systems. I have been to the adult systems.
Okay, so we're talking about the juvenile.
Correct.
And I was just trying to, in the agency, be here shortly. I have, and they have access to the telemedicine. They are in rural settings, so they don't have the professional physician or nurse practitioners that they need. But we'll hear from the agency that I was just wondering if you know, quite frankly, how much they do use the telemedicine.
Actually, yes, I recently looked at the CJJD's report and showed the year-by-year growth of the psychiatry aspect, and until it was minimally used maybe once in the cumulative perspective of all 5 sites, all year by year, until 2020 when COVID hit. And it was only the fact that COVID that allowed for that use. So there's a huge disparity between the mental health use, around 4,000 per year, versus 0 to 1 in non-mental health. And there's significant reports about the physical health needs.
Adult or juvenile?
I'm sorry?
Adult or juvenile system?
Juvenile. So that is partly what my hope is to help the committee understand is it's currently used in mental health capacity. This bill would allow the access to non-mental health, and there's significant reports, significant data that shows from diabetes to obesity to asthma, all of these conditions do not get addressed in a timely and accessible fashion because of the mental health only restriction to it. Whereas you have the access to remote access. We do this with Indian health service providers, our adult correctional facilities. In essence, our children are in their growing and developmental years. Their normal development physical aspects, their well child visits are not addressed because only mental health is allowed to be utilized. And this is an opportunity to expand from mental health to physical health as well, and therefore allow access for.
So it's your testimony or your belief that they only use telemedicine for psychiatric matters?
As the bill is currently written, it is mental health that is allowed for telehealth, but not other non-mental health uses. This bill, as is proposed, would expand that, and that's why I'm in favor of it.
Dr. Obey, if I could, Mr.
Sure,
Chairman.
Senator Miles.
Dr. Obey, correct me if I'm wrong, in doing the physical mental health, you can actually do that to a savings to the state of Texas, is that correct?
Say what?
You can actually do that to a savings for the state of Texas, is that correct?
Absolutely.
Look at the numbers.
Absolutely. We've done this at least 8 adult sites, and the significant savings, both from a safety and cost perspective, is
What
overwhelming.
are the 8 sites you're referencing?
So off the top of my head,
Texas sites?
one in Texas, the federal detention center in Houston.
Okay, well, I live and breathe this stuff, and I'm shocked that anyone thinks, and we can have the agencies come forward, they have daily 7/24 telemedicine available for the adult, and I believe for the juvenile as well. Now, the good news is the juvenile's going through sunset. In finance, Senator Huffman, Senator Swartner, we're so of the opinion that you won't recognize the agency in a very short time because they're going to relocate near urban settings where they'll have the professional medical and nurse practitioners, psychiatric care, education, everything that they need that, quite frankly, they're not receiving now. So thank you for your testimony, but we're going to get to the bottom of this today.
Good. If I may make one comment to that.
Sure.
So I think the federal detention center in Houston is a great example that's located right in the center of the center of Houston, and 6-month backlogs in taking care of these patients, even despite the healthcare
Who's
centers
that?
around.
Who's the backlog with?
Their hypertension.
No.
cardio-
What agency, what facility?
This is at the federal level, Federal Bureau of Prisons, right? But they're located right in the center, and so the rural aspect of it, actually, still with that, this access would be important, even with physically and geographically relocating.
I'm sure the feds can do a lot of things better. Thank you for being here. We appreciate it. Rachel?
One other thing, Mr. Senator.
Sir?
Can I do one other thing, please, sir?
You sure can.
Your claim to fame is when a congresswoman was shot in the head and you rebuilt her. You want to talk about that just for a little bit?
Yes, sir.
Thank you. Thank you for obliging me this one question, sir.
That was that experience.
Really not on the agenda this morning, but as a courtesy, I'm going to do it, but
Thank
be
you, sir.
mindful of our time. We have a lot left on our agenda.
Certainly, I was one of the lead physicians that took care of Congressman Gabby Giffords during that unfortunate assassination attempt. And during that experience was how I got into telehealth because, in our ability to be able to provide for her while maintaining confidential security, we use telehealth extensively. And it's what started to open my eyes to how they access aspects of it in many different scenarios. And I think from that experience and moving forward, I've certainly got unique insights into how this, especially when it comes to our juvenile system, could really be a benefit, and hopefully expansion of this would allow that. But
Very well. We appreciate being here. Rachel Hampton?
Thank you, Mr. Chairman.
You're welcome, Senator. Ms. Hampton, please honor our 2-minute time frame.
Absolutely. My name is Rachel Hampton, and I'm the Chief Mission Officer of the Lone Star Justice Alliance. We're a legal services nonprofit that works to improve the life outcomes of youth and young adults in the juvenile justice system. We work on site at the Ron Jackson unit and then subsequently at the MART unit, working directly with girls who are survivors of sex trafficking. Youth within the juvenile justice system tend to be one of the most medically underserved populations, according to a recent report from the Kaiser Family Foundation. The same report found that over 2/3 of youth in juvenile justice residential facilities report some healthcare needs, including injury, problems with vision or hearing, and other illness. In addition to physical health needs of children, one of the largest challenges facing TJJD is that they have become a warehouse for our most vulnerable youth with mental health and trauma in the state. And that trauma cannot be supported through their county of origin or home. They are then sent to TJJD with the understanding that they are there to receive adequate and proper treatment for these conditions. However, as many of you know and have followed, TJJD has been in a staffing crisis since early 2022. Although making great progress with the success through the sunset, one of the most significant areas of this is felt in the healthcare services for youth, particularly related to the to managing the mental health care conditions and the provision of physical health checks and services. We have served girls incarcerated in the Ron Jackson unit in Brownwood, Texas, and subsequently the MART facility in McLennan, Texas for the past year, and can tell you firsthand about the lack of adequate professional healthcare staff at the unit to serve the needs of the kids that are detained there. SB 2134 takes a step towards addressing the physical and mental health needs of our most vulnerable youth in the state by ensuring that TJJD contracts and utilizes telemedicine services for detained youth and expanding the healthcare when a healthcare staff member cannot be present in the unit, which is often, Provision of telemedicine services is critical to ensuring stabilization and continuity of care for detained youth and ensures they have access to the broad array of treatment services they may need to keep them safe. Thank you for prioritizing the mental and physical well-being of our most vulnerable youth by supporting SB 2134 with committee sublanguage.
Any questions?
May I, sir?
Senator Miles.
So the scenario that you're drawing is that we need help right now in TJJD as it relates to the physical and mental health of our students.
Yes, sir.
Okay, so do you see a big liability in the gaps that we have?
I do. The lack of waiting or the time frame for waiting for services is an issue for our non-emergency, for our youth.
For non-emergency? Okay, so what you're saying is this particular bill would help put in some more telemedicine that's desperately needed because we don't have the resources. Is that correct?
Yes, sir.
Okay.
Thank you, ma'am, for being here.
Mr. Chairman, thank you. I'll be right back.
Dr. Lepore?
Hey, good morning. Scott Lepore, Medical Director for Texas Juvenile Justice Department.
Tell us what's going on.
So I've been...
My impression that y'all are using telemedicine widely and often. Is that correct?
So as the bill reads, it's consistent to what we're already doing. I've been in this position for about 4 years. My understanding is that with UTMB and TJJD, it's been utilizing telemedicine for about the last decade. As already mentioned, we've maximized it with psychiatry service. 100% of telepsychiatry is telepsychiatry, so we use telemedicine for that. We prefer both UTMB and it's collaborative with TJJD, but on-site physicians doing a physical exam on a patient when available. There was mention about it would expedite appointments into the free world community when we need specialists, but it's just appointment time frame, so it's when the physician's available. And we're always open to increase the care that we provide for our youth, and if that is in a way maximizing telemedicine or telehealth in other ways, we would certainly do that.
Certainly. Well, let me thank you for what you do. I know you're working.
And the same for you.
In a difficult system. We all realize the agency has been challenged for years. When we reformed it in 2007, they had 5,000 clients. Now we're down to 600. The good news is, Senator Miles, most of those young people that are not confined at a state facility are back home in juvenile probation, receiving treatment closer to their family. And this session through sunset, the agency is being completely transformed with 2 smaller facilities and even a mental health facility. So a lot of changes are taking place, and I'm very optimistic and pleased with the current leadership that understands that they have a very challenging clientele and they need to be near the services. And it was my understanding that telemedicine is readily available for your clients.
It is.
Thank you for being here.
Chairman, one question.
Yes, sir, Senator Miles.
I'm not trying to be difficult, Mr. Chairman, I'm just trying to get clarification.
You're a senator, Miles.
You said it 3 times when available, when doctors are available, 3 times.
That's right.
So it sounds to me as if the doctors are not available and you're using telemedicine more and more and more. Is that correct, sir?
That is not correct in the way that I'm interpreting your statement. So we have medical providers, we are staffed sufficient enough that we provide physical exams in person to every youth that needs it. So we do triage. So if a youth puts in a sick call request, they're added to a schedule just like your child would be in free world care.
Mm-hmm.
If that child needs to be seen sooner, then it's addressed by the physician on call. Does this child need to go to an emergency room? Does this child need to, because it's an urgent visit that would escalate? But they would need hands-on assessment either way.
Okay.
But that child is going to be given an appointment within a week. If they've already missed appointment, and the providers, so that said 1 day a week we have providers on site, but it can be more. So if there's more appointments needed, those physicians come back and give more care.
So point of clarification, last question. We are doing more and more telemedicine to make sure that the kids are being seen. Is that correct?
I think what needs to be clear is that telemedicine is extremely beneficial.
Okay.
It does not take precedent over a physical exam, right? If my child is injured, I want a physician auscultating those breath sounds, heart sounds, doing the physical exam. Always will trump a telemedicine where we're leaving out those capabilities of what a physician's trained for. So we want to provide the best care that we can and utilize telemedicine to its maximum capacity for our youth. Absolutely.
Absolutely.
And we're always open to improve our care.
Doctor, thank you.
Thank you.
Thank you for being here, and I know you've got a tough job, and I appreciate you.
I appreciate you.
Maureen Wellington. I probably butchered that name real good. Maureen Milligan. So much for that. Amanda List, Texas Appleseed. Jacqueline Benestani. In support, Zing Grove, Texas Juvenile Justice Department is a resource. Chair's going to call it. Is Miss Carter here, the director? You want to come down and let me publicly thank you for the job you're doing. State your name and who you represent.
Chandra Carter, Executive Director of Texas Juvenile Justice Department.
We did not sign up, but I thought you'd be the best. How long have you been on in your current position?
I have been in the ED position for about a year now. It was interim for a period.
So you've been a part of, in consultation with members of the legislature that are going to give you the resources to have the care and confinement that your clients need and deserve, which would include telemedicine.
Yes, sir.
Yeah.
Yes, sir.
Is it your understanding that you currently have that available, as the doctor just testified, even emergency care using local facilities if necessary?
Yes, sir. Our primary use of telemedicine is going to be psychiatry. We have psychology on-site, and we have medical on-site and medical in the communities.
And the reason you probably depend on the telemedicine for psychiatric is because where you're located, the facilities.
Correct. Getting a child and adolescent psychiatrist to a facility, one of our rural facilities, would be exceptionally difficult.
Well, thank you. And I know Senator Huffman and Senator Schwartner and others have done this outstanding job of going to give you the resources and a model to go forward. So
yes, sir.
Thank you for being here.
Yes, thank you.
Anyone else would like to testify for Senate Bill 2134? If not, public testimony is closed. Leave the bill pending. Springer, you've been awful patient this morning. Senate Bill 2593 by Springer.
Thank you, Mr. Chairman and committee members. It's that time of session. We're all bouncing around, and I respect those that have just a couple witnesses and somebody traveling, so I don't mind and happy to be patient. Committee members, law enforcement officers are legally justified to utilize force in many situations, but being in many situations to bring suspects to justice, protect others, and for their personal defense. Obviously, less than lethal force is preferred. This bill encourages the use of less than lethal force by officers. It gives police officers a defense to prosecution when using less than lethal force. The law would allow a defense to prosecution for peace officers acting in their official capacity that use non-lethal force for the charges of assault, aggravated assault, injury to a child, elderly individual, or disabled individual, and deadly conduct. I know we have witnesses from both TMPA and the Sheriff's Association, but I have an expert witness, gentleman Joe Hawkins with the Dallas Police Department, who is an expert in less than lethal expert, and so I'd ask you probably call Joe up
Mr.
first.
Hawkins, Joe Hawkins.
Mr. Chairman, I just had a couple of questions of the author.
And I was going to say, happy to answer any questions.
Yeah, Senator Springer, I read your bill, but it seems to me that it would actually provide more encouragement of use of tasers and beanbags when actually they've been shown to cause harm to many people out there are just demonstrating peacefully.
I think when we look at this, it's like it's also a choice whether you use your pistol or rifle versus using a beanbag and a taser, and we obviously would choose to use less than lethal there. If somebody's peacefully protesting, I don't think anybody would want to see that, and from that standpoint.
But they already have that choice. They're not.
And this encourages them to use that less than lethal choice.
Why do they need encouragement? We know many cases where you have a person who's tasered who dies from the use of a taser.
And again, they chose that less than lethal, and there are going to be incidences that things happen. Whether from and I'm sure our experts can testify this. Those aren't pinpoint accurate locations. When you shoot a beanbag, you don't know what somebody may have that causes a reaction that you didn't know, but you used your judgment that you stand up for that says, in that circumstances, I felt like this was the proper thing to be doing.
Well, they do have that discretion right now. I mean, they have a judgment to use a less lethal weapon. What we're doing with this bill seems to me that we encourage them to use that when they don't need any encouragement. They already use that by everything that I know and everything I read and every experience that I have in terms of what I see happening.
And I think Officer Hawkins could probably address that even further for you.
Well, I understand that, but I mean, you're the author, so
I understand.
Thank you, Mr. Chairman.
Chairman Flores.
Thank you, Mr. Chair. So, in this discussion, have you heard of the thing called the force continuum? The force continuum. You've heard of the force continuum?
I've heard of the term, but obviously don't know near to the level that you.
Force continuum is police officers are trained to use different degrees of force according to the circumstances, and so you start, with verbal, and then you begin with. If verbal doesn't work, then you go to hands. Use your hands, and if it continues to escalate. So basically, what your bill, as I understand it, in the force continuum. And Senator, you brought about people demonstrating, but the things have escalated beyond, halt, stop, and it's gone to where it's becoming physical, but yet not to the degree of the elements of use of deadly force, where imminent threat of serious injury or harm or death is present.
And they have that option right now.
But it's in the force continuum. So what I understand is that while we're in the force continuum where we're using non-lethal force to address that portion of the force continuum that's not verbal, that's not deadly force, and yes, there's sometimes people have underlying medical conditions on whether you're talking to them, whether you're touching them, whether you're escorting them, that things may occur. But when you're dealing in the overall totality of circumstances, I understand this bill addresses that while you're in that part of the force continuum that you're using non-lethal force to bring things back into order, that they would not should the fatality occur, that they would not be held liable to the degree of the extreme end of the force continuum penalty. Is that what I'm understanding?
That's the intent. Thank you.
Mr. Chairman, that is not a correct statement, Senator Flores, if I may.
Yes, please.
Because what it does, it provides protection for reckless conduct by a police officer. Because they use a taser, they end up killing someone, or they use a beanbag that kills someone. I mean, I think that police officers, law enforcement, have that option right now. And they use the judgment and training, whether or not what degree of force to use. In whether it's demonstrations, if they continue to get more violent, of course they have the option to use higher type of weapons that we made to deal with the situation. But I'm just saying that they already have the training, they already have the option. Why are we going to all of a sudden put in a statute to provide? Actually, what it does is shields the police officer from any type of liability for their actions. That's what the bill is doing. More than anything else, they already know that they can use, have the judgment and discretion to use less lethal due course in
But
that.
wouldn't be, I recognize it then.
Sure, Senator.
Yes, Senator, and thank you for your comments and your experiences, and I respect highly, but I think it has to do a lot with intent, and the intent of recklessness is known or should have known, as I recall. And so if you're using non-lethal force and your intent is non-lethal, then, so does it go into the reckless category of the intent of known or should have known that this would cause serious injury or death? I think that's not the intent if you're using non-lethal force at this point in the force continuum. So that's kind of where I'm at looking at that, Senator.
And what I would ask you, Senator Host, when you say it shields them, if they're following their training and they're following orders at the site and someone's injured, do you really believe they should be charged with a crime? Following their training, following the instructions of their superiors at that moment, and someone's injured from either the beanbag.
Not necessarily.
Well, that's what's happening, and I understand that's the rationale behind this bill. You know, when you have incidents where, and we'll hear from our witness, they're trained, they're at the site, they're instructed to use that less than lethal, and then the shot goes off and injures someone, now they're charging the police.
Mr. Chairman,
you think that's correct?
You do that on a case-by-case basis. Sometimes it is warranted for them to use that type of force. Sometimes it is not.
But that doesn't change the fact that they were trained in that.
No, I understand that. I
And
hear
they
what
were
you're saying.
instructed to use that.
I understand that.
Why are we allowing our police officers to be charged with a crime for following their training and instructions of their superiors?
Well, they can still be charged with a crime under this bill. It's a civil liability that it's shielding police officers for being reckless and using greater force than necessary of the
But they were
situation.
doing what they were told.
I just answered your question, Senator Whitmire, is that they can do what they're told, but it's on a case-by-case basis.
Yeah. Senator Miles.
Thank you, Mr. Chairman. Senator Spring, I just want to make sure I understand this bill correctly. Auxiliary non-lethal tools that you're trained in, you use them and you take a life with one of them. In your bill, as I understand it, as I read it, it will give the officer a pass if they used them right, they were trained to use them right, but they're still, just because they're not lethal weapons, but they were used and somebody died, you want to give them a pass on that. Is that correct?
And I would say and I would say to that answer, though, I would add into that, that the officer, on line 20, the officer did not intend to cause bodily injury, serious bodily injury, or death.
Okay.
He did not intend to cause death.
But anytime you pull out any type of weapon, there's a possibility of death, whether it be lethal or not. There's always a possibility when you pull out that weapon. So you want to give them a pass. Did I understand that part too? Correct?
And I'm saying when they follow their force
continuum.
continuum,
Answer that question.
yes.
You want to give them a pass.
If they're doing everything per the bill, yes.
What do you mean give them a pass, Senator Miles?
It means that they're not going to be found. They don't have to go.
They're not going to be charged for
They're not going to be charged for death.
Senator Whitmire,
Senator Hubbard.
whenever it's my turn. Are you good?
I yield.
Yeah,
Makes sense to me, but
Yeah, I'm very supportive of your legislation, Senator Springer, and I agree with Senator Whitmire. They're instructed and trained to behave in a certain way, and they do. And then there's an extremely unfortunate result, beyond unfortunate, of course. But I think you're setting up a defense to prosecution. Is that correct?
Yes.
Yeah. Which that just means it's a defense. So there's still, we have to make sure that the actor used or exhibited the device while discharging their official duties, and then they acted in accordance with certain sections. So, it's setting up a defense, which certainly the prosecutor has to consider before they make charges. But I don't understand if you have a police officer who is acting in good faith, he's fulfilling his duties or her duties, they've been instructed to either control a crowd or try to prevent a riot, whatever. These situations are usually pretty volatile situations. Police officers acting in good faith, It doesn't make sense to me that they're then treated like criminals, but this would give them a defense if certain issues were in place or circumstances were in place. Is that how I understand your
That
legislation?
is
I know
correct.
you have some experts, and maybe
That's correct, Senator.
we can clean that up, but I believe that that's all
And
this
you did a
does.
better job than I did.
As the
Well, no,
non-lawyer on
it's-
the.
I'm just-
the
Senator
dais.
Miles
that's
says
what we're
a
doing
pass.
here.
I don't think, we can still charge people, and Senator Huffman's done such an eloquent job of saying it sets up a defense. So anyway, let's get to our experts.
Yep.
Officer Hawkins, will you state your name and who you represent?
Yes, sir. Good morning, Chairman Whitmire and members of the Criminal Justice Committee. My name's Joe Hawkins, and I'm representing the Dallas Police Department in favor of Senate Bill 2593. My position on the department is I'm a less lethal managed response use of force instructor, subject matter expert. I've testified federal court, grand jury for Dallas County, and then have taught thousands of Dallas police officers and other agencies in the area with that. I'm certified as a master taser instructor, certified as a master OC instructor by Sabre, certified as an instructor in less lethal weapons by Defense Technology, pepper ball, along with ASP baton, use of force instructor, de-escalation instructor. Are my qualifications. I've been an officer for 23 years, 6 years before that with the prison system for TDCJ in the 90s. I've been an instructor in less lethal since 2004 and trained thousands of officers restarted every year. When we talk about less lethal, which is the proper term, we have less lethal versus non-lethal. Less lethal is what we as law enforcement use. Non-lethal is a NATO definition that is used by the military with that, but it's less lethal munitions. We're talking impact munitions for the most part here with this bill. What we're looking at is a defense to prosecution when officers use this within their line of duty, properly trained, follow the manufacturer's stuff on it, and it's a defense at that point, right? That we used it accordingly. Our intent is less lethal. It is not to cause serious bodily injury or death. It takes that option away and everything and allows us the use of not having to go to our firearms. I know it's came up about the riots and the protests. That is not the normal use for this. We use it in those situations, but those are the exceptions, the rarities. As Dallas police officers, we use this hundreds of times a year as patrol officers. We have 140 40 millimeters in patrol. Other agencies have beanbag shotguns that are used to incapacitate and help resolve a situation that otherwise taken away from us would be a lethal situation, right? Our ability to reach out a distance and incapacitate to stop the suicidal individual, the mental health individual that's threatening other
Would you
individuals.
say that if you don't use this, you're going to be required or the necessity to use lethal?
Our options are
I
going to
think
be
that's
very
what's-
limited.
That's what's before us today.
Yes, sir.
We either allow an officer to use the less than lethal, or you're going to be required to shoot somebody.
We're greatly
To
restricting
protect
our
yourself-
options.
To protect yourself or others.
Yes, sir. Greatly restricting our officers and everything. After the protests, after some of the incidents we had with criminal charges filed across the state with officers, we had officers outright saying they are not going to carry this because if they use it, they are going to get criminally charged. And that puts the citizens at risk at that point.
Senator Bettencourt.
Thank you. Dean, okay, look, I'm not a lawyer. I'm not a judge. I'm not an attorney. I'm just a citizen taxpayer. And I cannot for the life of me figure out why we're not voting this bill out and be happy about it. Because if somebody has a less lethal solution and that keeps somebody from being killed or other people being injured or worse, I'm trying to understand why we're even having any opposition to Senator Springer's bill. What am I missing here?
That, sir, I don't know is above my pay grade and level at that point, sir.
Well, it's apparently above mine because I can't figure it out either. Thank you, Dean.
Thank you, Chairman. And as I read the bill, I'm going into the weeds of the bill itself. Right now, you do have the discretion to use less lethal weapon, if you will, in any type of situation. Is that correct?
Yes, sir.
And I guess what the bill is doing is not necessarily shielding a police officer from liability for negligence but they are limiting this bill to assault, aggravated assault, injury to a child, deadly conduct. I mean, so I guess if I read the bill now, it's just limited to those charges, criminal charges.
Yes, sir. It's just the criminal side of it, right? Because what we fall under now is, and a lot of this is new technology, newer technology than when the penal code was originally written for these. That the options the officers had at that time was firearms. We didn't have less lethal impact munitions, beanbag shotguns, 40 millimeters, tasers, those type of devices, pepper ball. We didn't have those when the original statutes were written. Technology has surpassed the written law, and we're falling under being charged with aggravated assault with a deadly weapon because the 40 millimeter we're using a beanbag round out of a shotgun, they fall in as a firearm, right? And we think of firearm as lead bullets, metal bullets to kill, to seriously injure and or kill, cause death, and that is not the intended purpose of these weapons. Although they fall under the definition of a firearm, they're not being used as a firearm. Their job is not to cause serious injury or death. We're less lethal, right? We're trying not to. Do they cause injuries? Sure, right? The 40 millimeter round that we use as patrol is equivalent to a 99 mile an hour fastball. A major league batter that gets hit, and our aim point is hip flexor, is our main aim point for this because we want to take the legs out from somebody and stop their advancement and things like that, right? A batter in major league takes a Nolan Ryan 99 mile an hour fastball.
They're down.
They down. Some charge the plate. We have different reactions to that. And when things happen, officers need to understand that they're not going to get charged with deadly contact and deadly weapons at that point for using a less lethal.
So let me ask a question. I mean, I guess and I thought it was broader than that, but obviously it is not. It would not prohibit a police officer who is reckless and shoots in the face of a demonstrator, for example. The demonstrator could sue for damages if the demonstrator was blinded.
Yes, sir. So this is only criminal side. It doesn't hold civil liability, right? Even if the officer is fully functioning within his way he was trained, it's a dynamic situation. We have movement, everything else. No officer is perfect. No individual is perfect. No one is perfect, right? Do we make mistakes? But do we take the intention out of it, right? We're not intentionally targeting this stuff. Now, yes, like you bring up, if somebody intentionally goes outside of training, outside of policy, and they intentionally hurt somebody intentionally. I intentionally aim for the head that is outside of my training unless it is a deadly force situation. I intentionally go outside of my training, outside of the manufacturer's recommendations of the use. They could still be held criminally liable with this. And civilly, always.
Officer Hawkins, because of the current law, are you finding officers more reluctant to use the less lethal?
Yes, sir. Yes, sir, I have.
I think if nothing else comes out in this committee on the merits or lack of this bill, is that you have tools now that are less lethal, and because in recent times officers are being charged for using them, they're not going to be used as often, and so that would lead you in a dangerous situation to a lethal measure.
Yes, sir.
So that's
inhibiting that would increase the likelihood of officer-involved shootings. That at that point we are going to get serious bodily injury and/or death. I also have examples of the rounds that we use, the data sheets, if anyone would like those also.
Can I ask a couple?
Senator Huffman.
Yeah, a couple more questions. One, because it's something you said to Senator Hinojosa drew my attention. So you said unless it was lethal. So if it was a situation where they were justified in using deadly force, and there are those situations, we all know what they are, but they choose to use a less lethal option, all right, which they can do, I suppose, in some situations, to kind of contain the situation. And this bill would still cover them if, the way I read the bill, if if, very serious injury occurred. Do you understand my question?
Yes, ma'am.
Like,
So
they can make that choice. They could have used their firearm perhaps, or some that's probably what they have that would be lethal, but they choose to use something less lethal, and then some serious injury occurs. They should still be covered under this because they're following policy.
following
Is that
policy.
fair?
Yes, ma'am.
Yes,
That
okay.
we do have, and there are instances, and there could be situations where we would use a less lethal type of deal and escalate that to a deadly force type situation and still use a less lethal weapon system. Individuals armed with a knife, and all of a sudden,
That's a great
I come up with my less lethal weapon system, and he charges and pulls a gun.
Right.
At that point, I could take a lethal type shot with that because the danger to myself and other people just increased to a deadly force situation at that point.
So some of these are going to have to be looked at situation by situation, but this bill will help law enforcement to feel like they can use these less lethal approaches and be protected in the appropriate situations from indictment, because this isn't just hypothetical kind of bill just to play around with because something happened in another state. There are actually officers in this state right now that are under indictment, correct?
Correct.
Yeah, both in Austin, is my understanding,
Yes, ma'am.
and in
Austin.
Dallas.
Yes, ma'am.
Correct. And so, I mean, this is a real issue. And so, again, Senator Springer, thank you for bringing this bill. I think it's really great for law enforcement. I think it'll be good for our communities as well. Thank you.
Anything else? Senator King?
I just had one question, and maybe this is more for the author, but do we have less than lethal defined as broadly and thoroughly as we should? Because I know technologies will be changing, and I don't know if is there an industry standard definition for less than lethal out there that needs to be in the bill or anything like that? That's just, I guess, more of a comment than a question.
I would have to look to see what that less lethal, what the definition fully defined is, and if it's open enough for technology improvements and advancements, and that's a lot of always what we do around here. In the 6 sessions I've been here, it's a lot of technology.
I don't know if I was in
changes.
court and trying to defend somebody, and they said
Because people are always trying to improve.
Or,
I mean,
where does it say
in the last decade, 2
40
decades,
calibers
everybody's
less
trying to
than
figure out
lethal
how do we
practice
maintain law and order without killing our
No,
population.
believe me, I love your bill. I just want to make sure that.
No, you have all
that it's
known this
defined
as
clearly, because
law
that's what
enforcement
always happens in court is discussions over definitions. All right, thank you.
Thank you, sir. Thanks for the job you do. Chris Harris? State your name and who you represent, Mr. Harris. And we've got a large number of witnesses.
Sure. Yeah, my name is Chris Harris. I represent the Austin Justice Coalition. I'm here in opposition to this bill, strong opposition to this bill. Anthony Evans, Justin Howell, Sam Kirsch, Christian Warchikeski, Meredith Drake, Jose Herrera, Tyree Talley, Modesto Rodriguez, Brad Ayala, Saranika Alexander, Tracy Cates, Maya Van Oss, Stephen Oran, Nicole Underwood. These are just a few of the dozens of folks that were hurt during Austin protests by less lethal weapons used recklessly by Austin police. Just a handful of settlements in those cases have resulted in more than almost $20 million in settlements from the city. Okay? The use of these was not in accordance with training and policy. The Austin city policy was very clear that officers are supposed to prioritize innocent folks. Many of these people weren't even protesting. Supposed to prioritize innocent folks, and they should only be used in response to projectiles, dangerous projectiles like bottles or rocks. They shot at medics. They shot at people who are literally not even protesting, simply watching from afar. They're not used in accordance with what the manufacturers say. The manufacturers said since 2003, the same manufacturer provided the Austin products, that you're not supposed to aim at the head and neck, that you're only supposed to use these from certain distances. They didn't do that. Now, can they violate the city policy? Can they violate the manufacturer instructions and not intend to hurt somebody? Sure. Does that mean that they shouldn't be held liable? Does it mean that the people who lost eyes, who have brain fractures, who have skull fractures, who have brain injuries, who have permanent disability, should have no other recourse for justice outside of the civil system? I don't think so. This bill is dangerous. It will give a green light to using these weapons more and more recklessly because there is literally no consequence. And the idea that it will encourage more lethal weapons, if officers are going to face indictment and potential prosecution for the use of less lethal weapons, why would they not fear the same for the use of lethal weapons? It makes no sense. This is a retroactive attempt to preempt the juries of Austin and Dallas to ensure that they don't come up with an outcome that certain constituencies don't like. But the reality is that these weapons were used improperly, in violation of policy, in violation of training, in violation of manufacturer standards, and the officer's intent we can argue about, but ultimately that should not be on the state to prove beyond a reasonable doubt what their intent was in order to, again, provide any form of justice for people that were harmed. I strongly encourage you to vote down this bill. Thank you.
Thank you, Mr. Harris. Ms. Costello? Alaya Costello? Alacia Costello? Start to state your name, who you represent.
Good morning. My name is Alicia Castillo. I am Director of Policy and Advocacy at Texas Center for Justice and Equity, and we are opposed to this bill. I sat here with tears in my eyes and noticed tears in the eyes of many members of this committee when we heard from the families of victims of shooting, a terrible tragedy that happened in our state. And at the same time, I know that there are other families of other victims who have incurred injury and harm from officers who also deserve the type of justice that any victim of violence deserves in this state. And we don't endorse the green light, as it's been stated before, for officers who may be those bad apples that we're afraid of, right, to injure folks in the community and citizens in the community. And we understand that this body wants to signal their support for our police officers, and this is not the way to go about it because of the great danger that it would pose to the citizens of Texas. Thank you.
Thank you for your testimony. Kathy Mitchell?
My name is Kathy Mitchell. Thank you for this time. I will try to keep it brief. With respect to the bill, we have provided the sponsor, and I want to thank him for his openness to amendments to the bill. And I do believe that it would take some amendments to essentially achieve the bill that you all have discussed here. There are a couple of things. I have suggested narrowing the definition of less lethal because I do believe that it is extremely open-ended. And walking into a courtroom, it would be better if people actually knew whether this was a covered incident or not. I have also suggested the removal of 22.04, which is injury to a child, elderly, or disabled individual. That statute is actually written quite differently than the other assault statutes for a reason. The extra care that one would expect from anyone with respect to the disabled, the elderly, and children, we believe simply is kind of not what we're talking about in this particular instance. We would recommend very strongly that a line actually be added to the scenarios specifying that the actor used the device in accordance with manufacturer recommendations and local policy. That is not actually in the bill right now, and would, for example, address the question of using rubber bullet weapons against the manufacturer's instructions. There are certain instructions for how to ensure that those are, in fact, less lethal. And then finally, we would recommend that the standard, okay, well, my time is up.
Thank you, ma'am.
I would only ask that we would hope that you would pen this bill in deference to the victims in these cases to improve it before voting it out. Thank you.
Thank you, ma'am.
And I have written testimony.
Yeah, thank you. Scott Hendler?
Thank you, Mr. Chairman, Senators. I'm Scott Hendler. I'm here on my behalf of myself and my law firm, Hendler Flores Law, in opposition to the bill. I want to make 4 points. First, criminal law is generally based on intent to act, and this is intent of consequences. So take into consideration that this could create a dangerous precedent, a slippery slope, if you will. Take the very justified act we heard about, 726. If a drunk driver doesn't intend to kill people, should that drunk driver be immune from liability? I mean, that seems to be the absurd extreme. I gather that. But that is the approach that this law takes. Instead of focusing on traditional criminal law that is intent to act, it goes to intent of consequences. The next point I want to make is that I don't believe the bill adequately defines acting or discharging their official duties. It's a very broad and ambiguous standard, so I would encourage the committee to refine that. We also want to ensure that our officers exercise personal responsibility for their actions. Peace officers provide a vital need to our community, but they are guardians of our safety, not warriors. And by providing them with complete immunity to any criminal liability from their actions, it encourages those rogue officers who may use this as a means of injuring defenseless people.
Thank you, sir.
Thank you.
Kenneth Talley? Kenneth Talley is opposed to it. Shelby Yohanan? Oh, sorry.
Good morning, committee. My name is Tyree Taylor, and I'm representing myself today to speak on Senate Bill 2593. In May of 2020, I attended the Black Lives Matters protest with a group of individuals who were showing support and love for the community and the experience. That afternoon, I saw one of my deaf friends being injured by bullets, and so I stepped in to make sure that they could be safe. At that point, I was also shot 12 times from head to toe, even though I was on the ground in a fetal position. I was covering my eyes because I was worried about becoming blind as a deaf person. As a result of this, I've suffered financial damage. I've lost my home. I became homeless. And I have really suffered from PTSD after that. The individuals who shot me should be held accountable for their actions. As a deaf person, I felt like they've neglected the deaf community. Here in the city of Austin is the second largest deaf community in the United States. And knowing that, the officers should have exercised more care. I'm here to voice make my voice known that the changes need to be made, that there needs to be priority considering with persons with disabilities. The deaf community's safety needs to really be prioritized in the minds of our officers. Thank you for allowing me to speak today.
Any questions? Say thank you for appearing.
Thank you.
Shelby Buchanan. State your name, who you represent, Ms. Buchanan.
Hi, my name is Shelby Bohannon, and I represent myself. I'm here to speak in opposition of SB 2593. This bill would give police officers the go-ahead to use less lethal weapons without consequence. We already know that they are able to use them now, and they are currently covered. This will act to shield police officers engaging in misconduct with these weapons. The militarization of our police is a disgrace, and we are heading down a dark road if we encourage further use of these or any weapons. Just locally, many have been seriously injured by these less lethal weapons. This includes brain damage, skull fractures, broken bones, lost fingers, and more. It is already so difficult for those injured by police to ever see justice, especially in a criminal court. Giving blanket protection to these police to use these extremely harmful weapons however they'd like is senseless. And Senator Springer's bill is shameful. I ask that you please oppose it. Thank you.
Thank you. Andrew Alameo. Alan Moa.
Andrew Alameo, representing myself. I was present during the 2020 uprising when the Austin Police Department shot Justin Howell in the head with a beanbag round. For a while, nobody around him could tell whether he was alive or dead. He was bleeding profusely. Eventually, medics came in and scooped him away, checked for a pulse, and believed they were able to confirm that he was still alive. And then APD, the officers who were standing on the stairs of the police department, motioned for the medics to bring Justin Howell across the street so that an ambulance could more easily tend to him. And as the medics carried him, they shot the medics with rubber bullets, and one of them broke her thumb. I don't understand why a bill like this is necessary. Officers already know they can use less lethal force. I don't buy that if they're told to by their superiors that should justify using them. It didn't work at Nuremberg and it shouldn't work here. Senator Springer, like, the hell? Like, why? Like, this bill sucks, and I think you should feel bad for introducing it. I'm done.
Anyone else present would like to testify for or against Senate Bill 2593? Not public. We have a large number of witnesses that have signed up, do not wish to testify, that are in support, and a large number in opposition. We will read them into the record before we adjourn. Anyone else present that would like to testify for or against Senate Bill 2593? Not public testimony is closed. Senator King moves Senate Bill 2593.
Chairman, before we do it, I might just make a statement, a short statement.
Sure, Senator Henry.
You know, I do have some concerns about the bill, but I guess in talking to Senator Springer, he'll be open to considering some adjustments to narrow the scope of the bill.
If we can find a way that works to be able to narrow, I think we could take always open to suggestions on how we're able to do that.
Obviously, Senator, there's never a piece of legislation that can't be improved, and so it's a process.
That is correct.
We're gonna move it, and I think you ought to have input right up to the day that it's considered, and I'm certain Senator Springer guarantees that, and I certainly will.
But one thing, and you're correct, Mr. Chairman, but sometimes you have authors that say they're closed, will not take any amendment
That hasn't been my
whatsoever.
experience with Senator Springer.
But let me finish. I think, sound like Senator West. Let me finish. I believe Senator Springer will be open to discussions and trying to narrow what we're trying to do that in the sense of the purpose of this bill. Thank you.
Senator King moves that Senate Bill 2593 be reported back to full Senate with a favorable recommendation. Clerk call the roll.
Whitmire.
Yes.
Flores.
Aye.
Hinojosa. Huffman.
Aye.
Betancourt.
Yes.
King.
Yes.
6-0.
There'll be 6
Yes, sir.
yeses, no nays. Senate Bill 2593 is reported back to full Senate with a favorable recommendation.
Thank you, Mr. Chairman.
I don't think we want to certify this one. Yeah. Thank you, Senator. Is Senator Swartner here? I'm sorry, Pete.
We can vote on Zaffarini if you want to adopt the substitute.
While we're waiting, members, we never voted on Senator Zaffarini's bill, so Senator Flores moves that committee substitute for Senate Bill 24.
Wait a minute. Which bill? I'm sorry, I couldn't hear you.
Zaffarini's, 2479.
I have a short one, Mr. Chairman.
We have a lot of,
I mean, I'll vote on it.
well, let's adopt the substitute. Is there objection to adopting the substitute for Senate Bill 2479? No objection, it's left pending. Senator Swartner, 2589.
Good morning, Mr. Chairman, members. This has to do with repeat felony offenders in TJJD confinement and custody. Currently, those individuals that have two separate felony adjudications cannot be considered for a determinate sentence until after two separate felony adjudications. The current statutory structure causes habitual delays in the prosecution process. This bill would change that. This bill would allow and modify the confinement practices for those youths that commit felonies while confined in a TJJD facility by first removing the option to sentence 17-year-olds to adult community supervision after they commit felonies within TJJD's facility. It also narrows the circumstances for which a juvenile may be certified as an adult and transferred, with the goal of keeping more young offenders closer to home. And finally, it automatically qualifies certain felonies for a determinate sentence if the youth commits the offense while in TJJD custody. This was an issue that we heard testimony on in the sunset process, one that, however, was not considered appropriate to put into the actual sunset bill. And so I'm bringing a separate bill forward for your
That is
consideration.
a serious concern because the population you're speaking to in your legislation really prevents the care and safety of the other clients.
Of the other ones, yes.
So
This is
thank
about 1 to 2% of the population that, even though they are confined in a TJJD facility, continue to commit offenses of the felony nature to a lot of times the actual caretakers and restorative personnel and security officers in those facilities.
Very good. Thank you. We have Mr. Grove, who's Chief of Staff as a resource witness. Daniel Gajardo is a resource witness, Office of Inspector General, Juvenile Justice. Jack Choate, Special Prosecution Unit, is a resource witness. Jana Jones, Special Prosecution Unit, is a resource witness. Philip Budo, Judicial District Attorney, is in support from La Mesa, if he would like to testify. Amanda Lost, Texas Appleseed, is in opposition. Texas Criminal, Shea Place, Texas Criminal Defense Association, is in opposition, does not wish to testify. Ms. Castillo, with Texas Center for Justice and Equity, is in opposition. Anyone else present would like to testify for or against Senate Bill 2589? Chair hears none. Senator Flores moves that committee that Senate Bill 2589 be reported back to full Senate with a favorable recommendation. Clerk call roll.
Whitmire.
Yes.
Flores. Hinojosa.
Aye.
Huffman.
Aye.
Bettencourt.
Aye.
King.
Aye.
6-0.
6 ayes, no nays. Senate Bill 2589 is reported back to full Senate with a favorable recommendation. Senator Flores moves it be certified for local consent. Is there objection? Chair is none, so granted. Ms. Lamatia, Senator, Ms. Lamatia, Senator Lamatia. State your name. Senate Lamatia on Senate Bill 760.
Good morning, Mr. Chairman. Thank you for the opportunity to lay out Senate Bill 760. SB 760 allows a justice of the peace to order a blood sample from the body of a deceased person to help determine or confirm cause and manner of death. In Texas counties, there are several ways a JP can answer questions during an inquest, including looking at medical history, analyzing crime scene info, ordering an autopsy on the deceased body. While the third option is often the most effective, autopsies are costly for counties and have long wait times. On top of this, not all of our counties have a medical examiner, which increases the cost and time it takes to receive results. Currently, in cases of a suspected overdose, a JP would have to order an autopsy to determine the presence of opioids in the deceased person's system. The ability to call for a blood specimen in this situation would forego the need for a complete autopsy and allow results to be obtained in a timely, low-cost manner. Currently, a JP can order a blood specimen from a deceased person suspected of driving while intoxicated. This ability speeds up the legal process and reduces the financial burden on counties. SB 760 expands upon this and increases efficiency. Thank you, Mr. Chairman. We have JP here as invited testimony and happy to answer any questions.
Thank you. Any questions of the senator? Hear none. Judge Woolley? And we're trying to get to the session, so this bill is in great shape.
Well, I'm glad to hear that, Dean.
But you can testify if you wish.
Good morning. Judge Woolley from Waller County. I represent the Justice of Peace and Constables Association. We're in favor of this bill, obviously. Senator Lamontia has laid it out very well, so I won't take up much more time.
That's perfect testimony. Thank you.
I would like to add one thing to it, though.
You better hurry.
There is instances where I think this will help us find homicides that we're not finding right now. And I think that's a very good benefit to this bill, that we may leave it alone. And if we have a hunch and we draw some blood and find something, we can forward that for some things that we're not
Thank you,
finding.
Judge. Great job for being here. We have a number of witnesses that, if signed in, do not wish to testify. We'll read them into the record before we adjourn. Anybody else want to testify for or against Senate Bill 760? Chair has none so granted. Senator King moves it. Senate Bill 760 be reported back to full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire.
Yes.
Flores. Hinojosa.
Aye.
Huffman.
Aye.
Bettencourt.
Aye.
King.
Aye.
6-0, sir.
6-0, no nays. Senate Bill 760 reported back to full Senate with a favorable recommendation. Senator Flores moves it be certified for local and consent. Is objection? Chair is none so granted. If we'll hurry. Senator Flores. Senator Flores on 1248 has a substitute. Senator Flores moves the adoption of the committee substitute for 1248. Is there objection? Chair is none so granted.
Thank you, Mr. Chairman. Members, do have committee substitute. Last session, the legislature passed Senate Bill 576 by Senator Hinojosa, which was a great step in strengthening our state smuggling laws. With a drastic uptick in illegal activity on the border, smugglers are using parks and recreational areas to guide non-resident aliens into the country. The Border Prosecution Unit has estimated there have been nearly 14,000 cases in the border region in the last 2 years. Under the current statute, prosecutors are not permitted to prosecute cases on parklands such as state parks. Further modification to the smuggling statute is needed to address this issue. Committee Substitute 1248 will expand the conduct constituting an offense of smuggling of persons by adding a cultural resource site or area, natural area, open space area, or park to the smuggling of persons statute in the penal code. Additionally, provide that cultural resource site or area, natural area, open space area, or park have the same meanings assigned by Section 24001 Parks and Wildlife Code.
Very good, Senator. Nelson Barnes, District Attorney, is a resource witness. We're in good shape. Ray Shempus, Sheriff Association of Texas, is in support. Dean Batten, let me see if anybody wants to testify. Anyone like to testify for or against Senate Bill 1248? Chair is none. Public testimony is closed. There's a number of witnesses that will read into the record. Senator Bettencourt moves that Senate Bill 1248 be reported back to full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire.
Yes.
Flores.
Aye.
Hinojosa.
Aye.
Huffman.
Aye.
Bettencourt.
Yes.
King.
There being 6 ayes, no nays, Senate Bill 1248 is reported back to full Senate with a favorable recommendation. Senator Flores moves it be certified for local consent. Is there objection? Chair is none, so granted. Members, we'll have to come back after the session.
I have to go short.
I can do one.
I have to go real quick. So,
Senator Bettencourt on Senate Bill 1969. We'll get to you in a minute.
Thank you, Mr. Chairman and members.
Just tell the session to wait on us. How's that?
I wish I could. Concerns have been raised by certain public universities in Texas about sexual crimes being committed in or around campuses. Following 3 examples demonstrate numerous times people have been arrested near campus for sexual crimes. One individual with 47 total arrests, 30 for indecent exposure, was picked up on campus for public lewdness. One individual with 20 total arrests involving all sorts of vulgar things.
Thank you, Senator Benton.
Right, and bring up the 2 witnesses from University of Texas, Chris Miller and Adam Biggs.
I don't know what they could add that you haven't taken care of. Thank you, gentlemen. If you
Thank
want
you.
this bill passed.
Okay, right.
Anybody else for or against Senate Bill 1969? Public testimony is closed. Senator Huffman moves that Senate Bill 1969 be reported back to full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire.
Yes.
Flores.
Aye.
Hinojosa.
Aye.
Huffman.
Aye.
Bettencourt.
Yes, thank you.
King.
Aye.
6-0, sir.
6 ayes, no nays. Senate Bill 1969 is reported back to full Senate with a favorable recommendation. Senator Huffman moves it be certified for local and consent. Is there objection? Chair is none, so granted. There's a number of witnesses, gentlemen, that will read into the record, so you can get your per diem or whatever you need.
Thanks for being here.
Senator Hinojosa, Senate Bill 1433 has a committee substitute for that bill. Senator Flores moves its adoption. Is there objection to adoption of committee substitute for Senate Bill 1433? Chair is none, so granted. Senator Hinojosa.
I will do the short version, Mr. Chairman. Under the Texas Emergency Detention Statute, a person with a mental illness, and because of that mental illness is at substantial risk of serious harm to themselves or to others, may only be detained either by a peace officer or through an application for a warrant for an emergency detention through the court system. The goal of this legislation is to ensure that physicians have the ability to submit emergency detention orders applications electronically across the state. Senate Bill 1433 would require a judge or magistrate to permit a physician who applies for a mental illness warrant to do so electronically rather than in person. The substitute amends, deletes line 7-9 from the bill. And the reason for that, it addresses the NRA's concerns about the expansion of the authority of peace officers to seize firearms.
Thank you, Senator Hinojosa. Anyone like to testify for or against committee substitute for Senate Bill 1433? There's a stack. Steve Wolev, Texas Hospital Association.
Mr. Chair, just if there's questions, we certainly support the bill and its streamlined processes and makes helpful clarification.
Thank you for being here.
Real quickly, if I could.
Senator Huffman?
Real quick. Senator Hinojosa, all the questions from the NRA, those have all been cleared up. Is that correct?
That's correct.
Right, so we're good to go. Thank you.
Thank you.
Anyone else? Thank you, sir. Any public testimony is closed if there's no one else. Senator Flores moves that committee substitute for Senate Bill 1433 be reported back to full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire.
Yes.
Flores.
Aye.
Hinojosa.
Aye.
Huffman.
Aye.
Bettencourt.
Aye.
King.
There being 6 ayes, no nays, committee substitute for Senate Bill 1433 is reported back to full Senate with a favorable recommendation. Senator Flores moves that committee substitute for 1433 be reported back to full, be certified for local and consent. Is there objection? Chair is none, so granted. I'm going to hold you to that one. Senate Bill 1516 is author Senator King.
Thank you, Mr. Chairman, members. Longstanding practice has been that you have a habeas corpus hearing in the venue in which the subject is being held. This just puts in statute and clarifies that because there is some confusing case law after a situation in Kenny County and Travis County.
Very good. Any questions, authors? Jeff Swain?
Chairman,
Yeah, sure. State your name, who you represent.
Mr. Chairman, members of the committee, my name is Jeff Swain. I'm the DA in Parker County. I'm testifying in support of Senate Bill 1516, and I would just be happy to answer any questions the committee has.
I don't think there are any. Thank you for driving down here.
I've got a couple other ones in the house.
We're always glad to see you. There's other cards that do not wish to testify. We'll read into the record. Senator Huffman moves that Senate Bill 1516 be reported back to full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire.
Yes.
Flores.
Aye.
Hinojosa. Huffman.
Aye.
Bettencourt.
Yes.
King.
Yes.
There being 6 ayes, no nays, Senate Bill 1516 is reported back to full Senate with a favorable recommendation. Senator Huffman moves that Senate Bill 1516 be certified for local consent. Is there objection? Chair is none, so granted. We still going to probably have to come back. We done?
We're done.
You done, man.
We're done. Congratulations.
I was so busy. Y'all were trying to help me get through this morning.
Yeah, we were.
Well, I thank y'all. It's been a challenging morning, no
it
doubt.
has been.
We stay in recess.
All right.
See?
Perfecto, Dino.